Hello everyone, welcome to Dhyeyalaw. Today we will be discussing a recent judgment given by the Supreme Court of India. In Rameshji Amarsingh Thakor vs. State of Gujarat, the Supreme Court recently reaffirmed the paramount importance of eyewitness accounts in criminal trials. The Supreme Court placed reliance on its 2012 judgment Darbara Singh vs. State of Punjab to emphasize upon the importance of ocular evidence over the opinion of medical experts. The judgment underlined that eyewitness testimony, even if not detailed in every aspect, holds substantial value in establishing the sequence of events. Before moving any further with the case law, let me throw some light on the legal provisions emphasizing upon the importance of eyewitness statements. As per Section 118 of the Indian Evidence Act, all persons are competent under law to testify unless they are capable of giving statements or understanding the questions of the court due to the reason of their tender age, extreme old age or disease. This section even allows the statements by a lunatic person to be evidence in the court if such a person is capable of understanding the questions of the court. Let's have a look at another provision that qualifies eyewitness statements as an highly valuable piece of evidence and strengthens the status of such statements. This section is Section 134 of the Indian Evidence Act 1872. According to this section, no particular amount of witnesses are required to prove a fact. This section gives importance to principle of quality over quantity. Let's have a look at what happened in this case. The facts of this case revolved around the brutal killing of Jayanti Bhai, who had succumbed to knife injuries during the incident. The FIR was lodged by the brother of the deceased, who had alleged that the murder was committed by the appellant along with his father and brother. The prosecution's case was built on eyewitness account of prosecution witness, that is PW2, and dying declaration of PW4 and PW5, who also happened to be the brother of the deceased. Initially, the trial court had acquitted all the three accused based on the medical evidence. The High Court in appeal had reversed the acquittal and held that the appellant was liable for the offence of murder under Section 302 of Indian Penal Code. Aggrieved by the decision of the High Court, the appellants approached the Supreme Court in appeal, hence the present case. This appeal was heard by Supreme Court bench comprising Justices Aniruddha Bose and Justice Bela M. Trivedi. The court, while deciding the case, pointed out that the trial court has placed undue emphasis on relatively minor contradictions in witness statements while ignoring the overall testimony of prosecution witness. The Supreme Court in this case opined that just because there were more injuries than narrated by eyewitness, it will not negate the prosecution's version. The court was of the opinion that the discrepancies pointed out by the appellant are minor ones. An eyewitness to a gruesome killing cannot in disposition narrate blow-by-blow account of knife strikes inflicted upon the deceased like in a screenplay. On the aspect of discrepancies, the court was of the opinion that there are bound to be discrepancies between the narration of different witnesses when they speak on details. Unless the contradictions are of material dimension, they should not be used to jettison the evidence in its entirety. The Supreme Court, in the light of its judgment, Gurbachan Singh vs. Satpal Singh of the year 1990, highlighted the need to avoid undue reliance on fanciful doubt while considering the rule of benefit of doubt. With regards to this case, the Supreme Court emphasized that the evidence provided by the eyewitnesses and the post-occurrence witnesses was consistent and sufficiently corroborated with prosecution accounts of event. Thus, the Supreme Court upheld the conviction of the appellant under Section 302 of the Indian Penal Code and dismissed the appeal. The court cancelled the bail bond of the appellant and directed the appellant to surrender before the trial court within a period of 4 weeks.